Hello, I'm Professor Jeff Gully, and in this short video, we're going to discuss the various methods that a will can be revoked. So let's jump right in. When we talk about revocation of a will in general, a will is revocable and subject to change until the death of the testator. Now, the only ways that one can revoke a will are set forth by state law. So we always have to check our jurisdiction, look at the relevant statutes, and of course, there's going to be some case law on point as well. The three main methods of revocation we'll look at are revocation by a physical act, by operation of law, and by subsequent writing. So let's begin by revocation by physical act. That literally means like you can tear it up, you can burn it, destroy, cross out parts of it. Again, we look to the statute. What does the statute say? There are four basic requirements for a valid revocation by a physical act. Again, this is a general statement and it will depend upon your own jurisdiction's law. So a capacity to revoke, the intent to revoke, a satisfactory physical act performed on the will, and the simultaneous existence of those first three prerequisites. So they happen simultaneously. There's got to be that link. So for a capacity to revoke, it must be shown that the testator has a mental capacity to revoke a will. So the example from the textbook in our class in PA221 is that the testator executed a valid will in 2010. Then in 2015, the testator was adjudicated to be incompetent by a court. Later, in 2023, the testator physically destroyed the will. So the question posed here is this revocation effective? So if we look at the capacity issue, if the testator lacked the mental capacity when the testator destroyed the will in 2023, no revocation occurred. What we also must examine is that an adjudication of incompetency does raise a presumption of lack of capacity, but any heirs can rebut that presumption by showing that the testator destroyed the will when he or she was actually lucid. Also, the testator must not be under duress when the will is actually revoked. And then we've got intent. We must examine the actions of the testator because they must clearly show, in order to revoke a will, an intent to revoke. What is the actual intention of the testator? So jurisdictions do vary as to whether a physical act such as burn, tear, or cancellation must actually touch the words on the will. So the modern trend under the Uniform Probate Code, Section 2507, is that these acts will operate to revoke, even if the burn, tear, or cancellation fails to touch the words on the will. So there are various examples in the textbook on page 158 that explore this intent to revoke element a little bit more. Partial revocations. Well, states have adopted different ways of regarding the ability of a testator to revoke parts of the will in contrast to the entire will. So physical actions such as interlineations, words added to that existing text, strikeouts, so the text is marked out but still readable, and complete obliterations, where the text is marked out and no longer readable, like it's redacted, basically, like blacked out. And one can make some really good, strong policy arguments on both sides of the issue. So what does the Uniform Probate Code say about this? In Section 2507, partial revocations are permitted under the modern approach used by most jurisdictions today. And so the goal of the court in resolving this is to carry out the testator's intent, which believes that these kind of changes are effective. Now, there is the possibility of fraud with a partial alteration. So an argument is that it's just as possible for fraudulent destruction of the entire will, just as it is a partial alteration. Revocation by operation of law. So rights that pass to a person by applying the established rules of law without the act, knowledge, or cooperation of the person. So the law itself revokes. For example, by marriage or divorce. A will can be revoked wholly or partially by operation of law. So the law says to protect a spouse from being disinherited or receiving only a nominal share of the deceased spouse's estate, common law marital property states permit the surviving spouse to claim a specified share of the deceased spouse's estate, regardless of what the actual terms are in the will. So we have to look at the statutes in those common law property states. Statutes in most states hold that all provisions that favor the former spouse contained in a will executed during the marriage are actually void. So again, we have to really focus on what does the law say in our respective jurisdictions. The death of a beneficiary is another way the will is that can impact the will, right? So a gift to a beneficiary who predeceases the testator is automatically revoked because property can only be transferred under the will to people who are alive. We have to still check state law on this. Some statutes will prevent the gift from actual lapsing by substituting other individuals as the beneficiaries of the actual gift. So again, what does the law of your jurisdiction say? Okay. What if the beneficiary killed the testator? Well, no. The law does address this. A beneficiary cannot speed up the receipt of property under the testator's will by actually killing the testator. Under Uniform Probate Code, Section 2803, if the beneficiary murders the testator, that beneficiary will be precluded from taking a beneficial interest in the property, either by statute or through what the law calls the imposition of a constructive trust in order to prevent unjust enrichment. Another way that a will can be revoked is by a subsequent writing, a new will, which is recommended. So if you're going to revoke a prior will, let's draft a new will. Many attorneys will provide that, will say that as legal advice. Or you have a codicil which has become almost obsolete, but both revoke or change the terms of a will. Again, what does the Uniform Probate Code say? Section 2507. Again, a prior will or any provision thereof may be expressly revoked by a subsequent writing. That's the preferred method because it clearly shows what the testator intended to do, right? Put it in writing. In fact, if you look at a typical last will and testament, it's common to see that testators will include an express revocation provision right at the beginning of the will in the introductory, or we also call that the exordium provision, that introductory clause. So here's a sample of one. I, John Smithson, a resident of Brooklyn, New York, Kings County, declare that this is my last will and I revoke all prior wills and codicils. And then we look at the situation where two wills are found. This does happen, right? So in this case, John Smithson has passed away, and two wills are then located by John Smithson's family and heirs. One expressly revokes all other wills and leaves Smithson's entire estate to his spouse, Eric Smithson. The other expressly revokes all other wills and leaves the entire estate to the children, Lane and JL. So, what do we do in such a situation? What's the proper distribution of John Smithson's estate in this scenario? Well, we got to look at, again, respective law, but if both wills contain the date of execution, or if that date can be ascertained from other extrinsic evidence, Smithson's estate will pass under the most current will, which is the one executed closer in time to Smithson's death. That document would reflect the testator's most recent intent, after all. But If one or both wills are undated and there's no evidence as to which one the testator executed first, most courts will hold that neither will could be given effect because of the court's inability to determine the testator's intent. In such a case, the law would say that the testator would die intestate. So that's a wrap up of our short video on ways that a will can be revoked. Thank you for tuning in.